This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about something slightly related to insurance, where a prisoner tried to get help after his conviction and lost because the unrelated witness misconduct turned out to be no help at all to a convicted shooter, and that the prisoner learned that when you do the crime, you must do the time. Louis M. Soto appealed pro se, acting as his own lawyer, from the order dismissing his second petition for relief filed pursuant to the Post-Conviction Relief Act, or the PCRA of Pennsylvania. In Commonwealth of Pennsylvania versus Soto, a May 14, 2024 decision of the Superior Court of Pennsylvania, the appellate court gave consideration to all the pro se claims only to see them quashed. In 2013, Soto discharged a firearm into a large crowd of people in Philadelphia, killing one person and injuring three others, including Larry Robinson. Madeline Soberal, a witness to the shooting, was initially reluctant to speak with police, but after interacting with Officer Carmen Sanchez, identified Soto as the shooter from a photo array. The matter proceeded to a consolidated jury trial in which Soberal testified that she was a few feet away from Soto when he pulled out a firearm and began shooting into the crowd. Officer Sanchez testified that Soberal feared for her safety if she provided a statement to police and had to be convinced that the police would ensure her safety if she agreed to provide testimony against Soto. After Soto was convicted in May of 2022, the Philadelphia District Attorney's Office sent correspondence to Soto that revealed that each of the officers who testified with regard to his trial and conviction had been involved in various forms of misconduct unrelated to Soto's criminal case. For example, Officer Sanchez received a 15-day suspension after being found guilty of insurance fraud. Officer Cartagena was disciplined for using excessive force in an unrelated criminal matter, and Detective Crone was disciplined for both domestic violence incident and for authoring a racially offensive letter. None of the misconduct had anything to do with the shooting. Soto claimed that he was entitled to a new trial on the basis that, had the jury been aware of the officer's history and propensity for misconduct at the time of his trial, the outcome would have been different. The PCRA court entered an order dismissing the petition. The appellate court reviews an order dismissing a petition under the PCRA in the light most favorable to the prevailing party at the PCRA level. The PCRA court concluded that Soto's claims lacked merit. The court observed that the evidence of misconduct by the officers was completely unrelated to Soto's criminal case, and the appellate court concluded that the PCRA court's determination that the after-discovered evidence presented by Soto had no other use than to impeach the credibility of the officer's testimony at trial and is supported by the record and free of legal error. In his PCRA petition, Soto identified only one witness who would testify at an evidentiary hearing. That is, Assistant District Attorney Shoshana Silverstein, to confirm that she provided Soto with the police misconduct disclosure packet that is the basis of his claims. No witnesses at trial claimed that they were coerced by police, and the only evidence offered by Soto to the contrary was the isolated incidents of unrelated police misconduct included in the police disclosure packet. Soto's claims, therefore, were entirely speculative. The Superior Court concluded that the PCRA Court's decision to deny Soto's request for leave to amend his petition was supported by the record and free from legal error, and Soto's issues merit no relief. In my opinion, the essence of this case is that Soto must stay in jail. The fact that one of the officers who testified against Soto was convicted of insurance fraud and other officers were disciplined for unrelated issues had no bearing on the fact that Soto shot many bullets into a group of people and killed someone. It did not change, and he was not entitled to post-conviction relief nor a new trial. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 a week, sometimes 6. And you will also gain access to the more than 4,800 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. They're all free. And if you do, I'd appreciate it if you click on the like button if you watch on YouTube, or the thumbs up button if you watch on rumble.com. And if you're interested in more detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.